Constructing Basic Liberties. A Defense of Substantive Due Process. By James E. Fleming. Published by the University of Chicago Press. For Linda, Sarah, and Catherine. Due process has not been reduced to any formula. Its content cannot be determined by reference to any code. The best that can be said is that through the course of this court's decisions, it has represented the balance which our nation, built upon postulates of respect for the liberty of the individual, has struck between that liberty and the demands of organized society. If the supplying of content to this constitutional concept has of necessity been a rational process, it certainly has not been one where judges have felt free to roam where unguided speculation might take them. The balance of which I speak is the balance struck by this country, having regard to what history teaches are the traditions from which it developed, as well as the traditions from which it broke. That tradition is a living thing. A decision of this court which radically departs from it could not long survive, while a decision which builds on what has survived is likely to be sound. No formula could serve as a substitute, in this area, for judgment and restraint. Justice John Marshall Harlan II, Poe v. Ullman, 1961, dissenting. The identification and protection of fundamental rights is an enduring part of the judicial duty to interpret the Constitution. That responsibility, however, has not been reduced to any formula. Poe v. Ullman, 1961, Harlan J. dissenting. Rather, it requires courts to exercise reasoned judgment in identifying interests of the person so fundamental that the state must accord them its respect. That process is guided by many of the same considerations relevant to analysis of other constitutional provisions that set forth broad principles rather than specific requirements. History and tradition guide and discipline this inquiry, but do not set its outer boundaries. See Lawrence v. Texas, 2003. That method respects our history and learns from it, without allowing the past alone to rule the present. The nature of injustice is that we may not always see it in our own times. The generations that wrote and ratified the Bill of Rights and the 14th Amendment did not presume to know the extent of freedom in all of its dimensions, and so they entrusted to future generations a charter protecting the right of all persons to enjoy liberty as we learn its meaning. Justice Anthony Kennedy, Obergefell v. Hodges, 2015.
Sample complete. Ready to continue?